President, my very respected colleagues, Dino Melaye, Kogi West. I want to start by congratulating my buddy and friend, Festus Keyamo, and our relationship actually dates some years back, not recent. I just want to start by saluting your intellectual sagacity. And from your CV, you've practiced law in and out. And this practice has been so recognized by awarding you the highest title any lawyer can earn in this country, the Senior Advocate of Nigeria. And you have been a prosecutor with the EFCC for so many years. So I want to quote section 174 of the Constitution and then ask my question in that regard. Section 150 talks about who is qualified to be the Attorney General of the Federation and the Minister of Justice. Section 174, with the permission of the chair, I read. 174 says the Attorney General of the Federation shall have powers to any person, to bring any person, before the court of law in Nigeria or other than a court martial in respect of offenses created by or under the Act of this National Assembly, to take over and continue any such criminal proceedings that may have been instituted by any other authority, persons, and to discontinue at any stage before judgment is delivered by any such criminal proceeding instituted undertaken by him or any other person. That is what we call the power of nolli prosecute. But that power, Mr. President or Mr. Chairman, and my respected colleagues, can only be exercised conditionally. So the Constitution in 2 gave those conditions that must be met before those powers can be exercised. And it really does. The power conferred upon the Attorney General of the Federation under subsection 1 of this section may be exercised by him in person or through officers of his department. In exercising his powers under this section, the Attorney General of the Federation shall have regard to 3 things. 1, public interest. 2, the interest of justice. And 3, the need to prevent abuse of legal process. I want to ask you, as a qualified lawyer and a man who is even qualified for the office of the Attorney General of the Federation, but I'll venture the President send you to the Ministry of Justice with all your area of experiences. Do you think in the last 4 years, the powers of the Attorney General to grant nolli prosecute have met these 3 conditions? 1, that of public interest. 2, the interest of justice. And 3, the need to prevent abuse of legal process. Litany of nolli prosecute have been granted, but I want to ask you, using your celestial mind as an activist, to respond to this question. And secondly, I just want to say that as a versatile minister, I know you to be intellectually mobile. You recite the 2nd stanza of the national anthem. Thank you.
That is not a question. That is not a question. So you have asked about 2 questions.
Sorry, Mr. Chairman.
The single leader, Dino, that is not a question.
Mr. Chairman, screening as described is to screen a candidate. And excuse me.
No, it's okay. That is not a question. You have asked very, very direct questions, so you can disregard the latter part. You can respond to the questions, please.
Thank you. Thank you, the President of the Senate. Let me start with, because of the constraint of time perhaps that we'll run into, let me start with the question asked by distinguished Senator Ovie Omo-Agege. The first question was the major reforms that I would like to see in the justice sector. We all agree that our justice sector has been beset by so many problems. And I think we don't doubt that at all. But then, let me say that I'll be prepared to serve in any capacity that the President wants me to serve. But if I'm AGF, I have what the idea I call the 3Ds that would be at the heart of judicial reforms, the 3Ds. And the first D is the decongestion of the Supreme Court. The second one would be the decongestion of the prisons. And the third one will be the decongestion of court lists in courts across the country. And that is, of course, linked directly to speedy trials. Now, as to the decongestion of the Supreme Court, I would not occupy the office of AGF for 4 years without unbundling the Supreme Court. That would be my first task, to unbundle the Supreme Court. Our Supreme Court is the busiest Supreme Court in the world. And it's just not acceptable. The kinds of cases that go up to our Supreme Court are scandalous. Interlocutory appeals. Appeals dealing with, frivolous matters. And I think this country is big enough now to have 6 regional Supreme Courts where appeals coming from those regions would end there in land matters, contract matters, marriage, and all of that. I mean, as the Supreme Court is designed today, you won't believe, distinguished senators, that a case of assault, I slap you, you slap me, will go up to the Supreme Court and be lining up with constitutional matters and political matters to be heard. That is scandalous. And that is why today, the cases at the Supreme Court are pending there for the last 10 to 15 years. Justice delayed is justice denied. The diary of the Supreme Court I speak with you now is filled up to 2022. You cannot get a date at the Supreme Court now till 2022. Yes, now, except political cases. And the political cases are compounding the issues again. So, I don't know why it has not been possible to simply establish regional Supreme Courts. And so the Supreme Court in Abuja would only entertain constitutional matters, political matters, and election disputes. Matters that have to do with the interpretation of the Constitution, because at that point you need the Central Supreme Court to guide the entire Supreme Courts across the country. And even at that point, in matters of constitutional interpretation, distinguished senators, it is scandalous also for a Supreme Court that has 21 justices, for 7 of them to sit to bind others, because the Supreme Court, by the principles of stare decisis, is bound by its own decisions. So if you have a constitutional matter going to the Supreme Court now, 7 justices sit, 4 can overrule 3. So you have 4 justices giving their opinion on a very serious matter, binding 17 others who have no opportunity to contribute to that judgment. And tomorrow, if those 17 others come, or part of those 17 others, and they want to determine that same matter, they will be bound by that decision, even if they have a separate view about it. It's scandalous. So there's something wrong about that system. In constitutional matters, I would press for constitutional amendment to make all the 21 justice seats, because that's our ground norm. The Constitution is our ground norm. So 4 people cannot determine our ground norm, where 21 are there. And then we're all bound by that. These are things that are wrong with our Supreme Court. So I will make a holistic unbundling of the Supreme Court and complete restructuring of the Supreme Court. Again, they have very scandalous applications. You see, there are things we borrowed from Britain that are still bogging us down in terms of delay of cases. For example, the provision in the Constitution of leave to appeal. It is there in the Constitution that you must seek leave to appeal in certain matters. Over time, leave has been granted as a matter of course. But for you, before you appeal, a matter where you have judgment against you, instead of you just having the right to appeal directly, you first file a motion for leave to appeal. That motion for leave to appeal is pending for 5 years. For you to just seek a permission to appeal. I mean, why? Why do we still allow these antiquarian laws in our Constitution? And these are things borrowed from Britain. It's only in exceptional cases they deny you leave to appeal now. Remove all provisions regarding leave to appeal. Let everybody have a right to appeal. Except, of course, the time to appeal, you can seek for extension of time. There should be time limit. But leave to appeal is antiquarian. Remove it from the Constitution. Everybody should appeal as a matter of right. And so you can unbundle the Supreme Court with all of this. The congestion of prisons, which is the second D, is that we are not complying with provisions of the law. I want to pay tribute to the 7th Assembly that passed the Administration of Criminal Justice Act. If you look at the provisions of the Administration of Criminal Justice Act, provisions have been made there, adequate provisions, to address the congestions of our cells and our prisons. For instance, every police station in every part of this country should open its cell to the nearest magistrate court at regular intervals for the magistrate to just come and say, open your cell, I want to see who are those you are detaining here and why you are detaining them. The provision is there. The DPOs are supposed to make returns to the magistrates to say, look, we have arrested this person, we are detaining them for this reason, and all and all. They are not complying with those provisions right now. Nobody is complying with those provisions. There are adequate provisions there. But the Administration of Criminal Justice Act is only applicable to federal courts because it's the National Assembly that passed it. Federal courts in Abuja and all of that. Now, it's only a few states that have adopted the Administration of Criminal Justice Act. I think Kogi and some other states. 1 or 2 other states. Now, for states that have not adopted the Administration of Criminal Justice Act, the scandalous situation we see now is that a person is arrested on a frivolous charge, arraigned in court on a supposedly capital offense. Once the magistrate court says murder, armed robbery, even without a proof of evidence attached, they just say remand. We must amend the law and encourage state governments across the country to amend their criminal procedure acts or codes to ensure that at the point the magistrate is entertaining the charge against those accused persons, instead of sending them to remand, the magistrate should have powers to call for proof of evidence at that stage. Don't tell me that you want to take the file to DPP for advice. I want to see whether you have proof of evidence. If you don't have proof of evidence, even if I see murder, I will release him on bail. If I don't see any proof of evidence attached. Because, with apologies to the police, they arrest people on the road. And because you don't have 5,000 for bail, the next day they just type armed robbery and take you to court and remand. And the person starts a journey of 6 years in the prison without bail. That file will be sent to DPP maybe 2 years later. The person is still waiting. The DPP gets the file, the DPP keeps the file for another 4 years. It's not attending to the file. Because of our corrupt system. If you got a corrupt DPP, unless the person has somebody or people to come and push that file will never live there for him to give us advice. When there is no charge, no evidence against that person. And so our prisons are full of these awaiting advice people. They are full. How can we avoid this? Let us give the magistrates power to grant bail in respect of so-called capital offenses if there's no proof of evidence at that stage. And then, even that of course links to the question that my very good friend Dino Melaye asked about the powers of the DPP and the Attorney General that are can be subject to abuse. I think it is high time we amend the law to make the advice of the Attorney General and DPP subject to judicial review. It's high time. The Attorney General and the DPP cannot sit down in their office and exercise the judicial function and say you have no case to answer. The powers were put there to protect, of course, people who will be charged, with frivolous offenses. That's why they put the power there, so that the DPP can say, don't face trial because it will be frivolous. But on the other hand, it is subject to abuse where people who are actually guilty are freed by the DPP by advice. So we should, and to answer Dino Melaye's question, Distinguished Senator Dino Melaye, that section 174, without indicting my very good friend Malami, because I know he's a gentleman, he wouldn't withdraw any charge if he did not see the fact that there is no offense there. And I can vouch for him. If there's any case like that, Malami must have seen that there was no case. I can vouch for Malami in my sleep. He's a distinguished colleague. But there are other attorneys general across the states who we don't know, who can exercise and abuse this power. And so, if the DPP gives an advice and say, there's no case against you, let gentlemen, distinguished senators, let us amend the Constitution to make that power subject to judicial review. So that the people who are aggrieved can go to court with that advice and call for the proof of evidence. And the magistrate will say, the Attorney General, you are wrong, because this case, as I'm saying, there's prima facie case against these people. Charge them to court. We cannot give the Attorney Generals the power of the judiciary to perform the functions of the judiciary. But let me say that the conditions in section 174 right now, the other scandalous provision there, you put conditions there, but you make them subjective. So Senator Dino Melaye is correct to the point that these conditions are put there. But do you know, the Supreme Court has ruled in several cases that you cannot question the discretion of the Attorney General. So the Attorney General says, I have looked at it, and those three conditions have been met. The Supreme Court said, well, it is his discretion. They will not even question that discretion. It is wrong. It's wrong. So our constitution is replete with mistakes, antiquarian provisions that we must amend.
Chief Keyamo, please respond to all the questions they raised, and then we call on Senator James Manager to make his comments or ask his questions finally.
Just quickly, so I don't exhaust the time. As to the restriction of political parties in the country, my humble view is that we must strike a balance between opening up the political space, which a democracy allows. We must open up the political space to everybody. Strike a balance between that and, of course, ensuring that frivolous parties do not put pressure on the public purse. I was the collation agent for Mr. President at the last election. And by the time they gave us the result sheet, it was like a big wrapper. Like the 74 parties, 74 candidates. Some of them did not even have up to 1,000 votes. Some of them had no votes at all in both parts of the country. So how do we allow, and then INEC has to now print ballot papers to accommodate them, the ballot paper, and then that's pressure on the public purse. How do we address this? Distinguished senators, I think we can strike a balance by saying, for new parties to be registered, you must show capacity at some small level first, before you now come and contest for presidency. Register political parties, fine, but you cannot run for president or senate until you go and run for local government election first. Until you win a councillorship seat, you can reduce it to even one councillorship seat. Until you win a councillorship seat, you cannot run for governorship. Until you win one governorship, you cannot run for senate, and on like that. And so you graduate. They show capacity to begin to graduate. They show capacity at that level. We can strike a balance by passing this kind of laws to ensure that we all participate in the political process, but we also do not allow all kinds of people to put pressure on the public purse. Now, the questions are so many. Distinguished Senator Okpeyemi Bamidele, my senior in the struggle, my leader and political leader and leader in the struggle also, asked the question as how I will handle activism and governance. I think people don't realize that governance is activism. It's just that because over the years, people have seen politicians as corrupt, as inept, and all that. It's wrong. We have distinguished senators here who are fighting for the rights of their people. They cannot fight for the rights of their people without being here. And I said before that there's only so much you can do as a private person. Being here, distinguished senators, you know what you are doing. You are fighting for consumer protection, you are passing laws on consumer protection, you are passing laws regarding the rights of the people and how to give them succor. That is activism. Activism is not, we have great activists here as senators. That is the truth. Activism is not when you just buy one Android phone and begin to abuse everybody every day. That's not activism. Or activism is not when you begin to burn down vehicles and march. That's not activism. Activism is how to bring, you say you are an activist and you are burning the cars of innocent people on the road. How are you bringing succor to them? Are those cars belonging to the president that you want to quarrel against? That's stupidity. I apologize. The greatest activists are those in governance, and the greatest activists are people in the legislature, in governance. That is how.
Mr. President, 2 more minutes, 2 more minutes.
And quickly as to my philosophy of life, I want to put it very simple, in simple language. I don't want to die without making a loud statement for society and for the poor and the downtrodden. I don't want to die. And that is why I've been restless since I was called to the bar. And I'm sure you know that I eventually grew up in front of the nation. Everybody saw me since I was in my 20s. I'm almost 50 now. But every single year, I have been restless in fighting for one thing or the other. And everybody watched me grow. The man standing here, is that restless young lawyer you used to do many years ago that has grown to become a senior advocate of Nigeria standing here before you. So I grew up before your eyes, virtually. And so I have been restless because I don't want to die without making a loud statement.
Time up, Mr. President.
And for this.